Good afternoon, Monica Miller here, the Legal Director and Senior Counsel for the American Humanist Association. This is Legal Tuesdays, where I answer your questions about separation of church and state. The question I will answer today comes from our email submission form, Scott McLean, who says, I was wondering if you have ever taken on the court and its mandates to AA meetings as being in violation of the Establishment Clause. To back up a little bit, AA is a program, a 12-step program. It has a parallel one for drug use, Narcotics Anonymous, Alcoholics Anonymous. Both of them use God belief or the belief in a higher power as their central premise, and that it's, as I understand it, you can't move forward in these programs without accepting a power greater than you. The courts have unanimously recognized that AA is a religious program, as well as its parallel Narcotics Anonymous, because they use theistic belief as their operating principle. We have not had to take on a case in the courts because this law is so settled. I have, however, filed or submitted letters to government entities across the country for violating this settled principle. In Torcaso versus Watkins, the U.S. Supreme Court ruled, I think it was unanimous, or maybe it was 7-1, and I know I've discussed this case in several of my videos now. But it's such an important case because the Supreme Court made really clear that the government cannot require citizens to believe in a higher power or a God. In that case, it was a public notary in Maryland who wanted to apply for public office. The Maryland Constitution had a provision saying that you can only apply for public office if you believe in a higher power. I think you had to sign some sort of affidavit attesting to your belief in God. And the Supreme Court said that is blatantly unconstitutional under our First Amendment jurisprudence, under just the Constitution in general. We are in a country where you cannot require God belief as a condition of being a citizen. And that includes being in prison. You cannot use Narcotics Anonymous or Alcoholics Anonymous as a condition for parole without offering a secular alternative. So I've sent letters to medical boards where doctors were prohibited from practicing medicine pending participation in Alcoholics Anonymous or Narcotics Anonymous. I've sent letters to prisons that have attempted to condition an inmate's parole or probation on participating in these programs. And the rule is that they have to provide an adequate secular alternative, or else they have to just either ditch the program or provide the inmate something else. They cannot allow someone to be in prison a day longer because they refuse to participate in something that requires them to believe in God. The Ninth Circuit actually had two really good cases on this. The second one, I think, resulted in a very large money damages award against a prison in Hawaii, I think, for violating a Buddhist rights. Every single day that he was in prison, when he didn't have to be because he refused on religious grounds to participate in AA, the court said was a violation of his bodily liberty for being in prison, and it was a punishment he wouldn't have had to suffer if he was not Buddhist. And Buddhists, at least the way he saw it, did not believe in a higher power. So the case law is really settled. All the more reason that if you confront this issue to please contact us. I'm actually working on a matter right now stemming out of Texas. It's otherwise confidential, but unfortunately these issues crop up all of the time despite the issue being as well settled as it is. So that's all I have time for today, but I look forward to talking to you on the next segment of Legal Tuesdays.